Okay, Ms. Underwood, you said you were ready to go with Mr. Bowen, is that right?
That's correct, Your Honor.
All right, this is file 24-21987-FH, People versus Daniel Don Bowen. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Berta?
Thank you, Your Honor. Christy Berta from the Attorney General's Office for the People.
Rhonda Underwood for Mr. Bowen this morning.
Okay, and where does Mr. Bowen's case stand today, Ms. Underwood?
Your Honor, Mr. Bowen continues to make regular payments. I've spoken with Mr. Bowen and the Attorney General's office, Your Honor, and I believe we've agreed to an adjournment in this matter for further payment history, Your Honor. So if we could perhaps do 60, 90 days.
Okay, Ms. Berta, anything to address from the people's side?
Your Honor, the arrearage is $54,280.58 as of January 16. I am a bit concerned because the income withholding stopped on December 21st. However, he has made biweekly payments personally since that time, the last one being received on January 14.
Oh. If I could, Your Honor, I made a payment yesterday morning.
Well, Mr. Bowen, you're represented by an attorney, so Ms. Wood, do you want him to speak directly to the court? Ms. Underwood, do you want your client to speak directly to the court?
No, Your Honor, I just would say that he is making the payment.
All right, what I'll do is adjourn this to March 19th.
Thank you, Your Honor.
So March 19th at 8:15 a.m.
And I have no objection to doing the stipulation with Ms. Berta's permission.
Of course, Ms. Underwood, you have my permission to sign.
And that's March 19th. Thank you.
Thank you.
All right, thank you, Mr. Bowen. You can go ahead and log out.
Thank you, sir.
Your Honor, I believe that's the only thing I have with you this morning, unless there are pickups.
Yes, we're all set. Thank you.
Thank you.
Mr. Hartung, who are you here for today?
Your Honor, I'm here with Mr. Amadeo on Mark Silvertooth. I also have Tessa Woolley, Taylor Cately, and Antoine Simmons.
Okay, we will call for Mr. Silvertooth right now.
Good evening, this is Kelly from Judge Olsaver's office. Mark Silvertooth and Judge. Great. Thank you very much. Bye.
Okay, Mr. Mawad, I have Mr. Sherwood here in the courtroom. Do you need a breakout session, or are you going to need to speak to him?
No, Judge, if I can just tell you briefly, I know Ms. McClure is getting on. You want to call it and we can just tell you what's going on? If you have,
Mr. Sherwood, do you want to come forward and you can stand at the podium, please? All right, this is file 24-21855-FH, People versus Charles Thomas Sherwood. We are here today for a pretrial conference in this case, and we are proceeding today by video conference, also in person. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
Good morning, Your Honor. Phoebe McClure, map the people.
Your Honor, good morning. Elias Muad appearing on behalf of my client there, the defendant. Thank you, Mr. Sherman.
And sir, you are Charles Thomas Sherwood, correct? All right. Mr. Muad, where do we stand with the case
Judge,
today?
I believe that we have worked out an agreement. That agreement was sent to me in writing, but because I was not in the office in the afternoon, I did not have a chance to confirm it with my client. I think it comports with what we were talking about. Does the court have any time for us next week to do a plea? If Phoebe, is that okay?
Yeah, so I can chime in a little bit. I know what we had kind of finalized was 10 days in Lenawee County Jail, or no more than 10 days in Lenawee County Jail initially. I wrote it up on the plea form, no more than 30 days initially because of his credit. I wasn't sure how much credit he had, whether that was already, 14 days or so.
Yep.
So I figured if I did 30, then he would at least have the 10 at sentencing to do.
Okay, Mr. Sherwood, I know we talked about this. How long were you in jail before you got bonded out?
I believe it was 18 or 19 days.
Okay,
Okay, so the 30 days with credit for time served is how it's written. That should comport with our agreement for no more than 10 days at sentencing. Otherwise, Judge, the agreement was to plead to a child abuse third degree and dismiss the remaining counts. And he would be allowed contact with his own minor children pursuant to any CPS orders, which is mirroring the current bond conditions on the case.
that's correct.
Okay, and so Mr. Muad, you want to do that next week?
Yeah, Judge, I just want to make sure that he understands what the plea is. It's not anybody's fault. We just, in the afternoon, I wasn't around. I wasn't able to get to him, and I want to talk to him, and his family's been involved too. So I would appreciate it.
Okay. Let's set over then to January 29th. That's next Wednesday at 8:15.
Okay. We're going to email the Mr. Sherwood, we're going to email you the agreement, and then you're going to call me later on in the afternoon, okay?
Yep.
All right, then Phoebe, I will talk to you later. Judge, you want me to do an order for this?
Yes, please.
Sorry about that. Thank you. Thank you very much. We'll talk to everybody later. Doug and Bill, we'll see you guys later, okay? Thank you, Judge.
Okay. Thank you, Mr. Sherwood. You are all set for today.
Thank you, Your Honor.
Okay, the person at the MDOC facility, can you tell me your name? I was not able to hear what you said. There appears to be an issue with the device there at the MDOC.
Awesome, thank you.
You're welcome.
Okay, and what was your name then?
Amberlyn Howell.
Okay. Okay, your attorney, Mr. Glazer, just logged in. Okay, Mr. Glazer, I do have Ms. Howell here from the MDOC. Do you need a breakout session with her?
Yes, Your Honor.
Okay. And Mr. Amadeo, I believe we have Mr. Silvertooth. Although the jail device is muted and has its video turned off at the moment.
Understood, Judge.
As soon as we get that corrected, we will proceed.
Thank you.
Oh, it's Kelly and Judge Olsavers. So we have Mark Silvertooth in the jail room.
Will you need to speak to Mr. Silvertooth, Mr. Amadeo?
No, Your Honor, we're ready to plea. Thank you.
Okay.
Your Honor, can you hear us over at the jail?
Yes, we can hear you now. Thank you. Okay. Okay, then this is file 21-20410-FH and 24-21829-FH. People versus Mark Silvertooth. We are here today for a pretrial conference, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Doug Hartung appearing today for the people.
Good morning, Your Honor. William Amadeo, P7619, on behalf of Mark Silvertooth. We can set and appreciate the Zoom hearing. Mark, please state your name for the prosecutor, Your Honor, and the staff to know it is you in the jail.
Mark Silvertooth.
All right, and the 21 case has an alleged probation violation. The 24 case is new charges. Mr. Amadeo, where do we stand with the case today?
Your Honor, it is my understanding, Mr. Hartung, correct me if I'm wrong, we're doing a global resolution on all files. He'll be pleading guilty to 1 count of distribution in the 24 file. He will also be pleading guilty to the violation of probation due to the guilty plea of the 24 file. This will clean up all his files. He will go on probation for 3 years after serving 1 year in your county jail. That's based on People v. Killebrew.
Okay, Mr. Hartung, is that a complete and accurate statement of the plea agreement?
Yes, Your Honor, it does confirm what we had our bench conference about, and specifically, Mr. Silvertooth would plead guilty to count one on the newer file, and the habitual charges will be dismissed as sentencing.
Okay. Mr. Silvertooth, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Mark Anthony Silvertooth, correct?
Yes, sir.
Mr. Silvertooth, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count one, delivery or manufacture of cocaine less than 50 grams?
Yes, sir.
Are you satisfied with Mr. Amadeo and the advice he's given you?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 20 years in prison and or a $25,000 fine?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been stated on the record here today. Is that correct, Mr. Hartung?
Yes, Your Honor.
Mr. Amadeo?
Yes, Your Honor. Thank you. That is accurate.
If a guilty plea is is that also your understanding, Mr. Silvertooth?
Yes, sir.
If your plea is accepted, Mr. Silvertooth, that means there'll be no trial. You'll be giving up all the rights that you would have had at trial. I'm going to explain those to you now to make sure you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at the trial if you wanted to testify. You understand, Mr. Silvertooth, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
How do you wish to plead to the charge that on or about July 19, 2023 in the city of Adrian, county of Lenawee, that you did commit the offense of delivery or manufacture of cocaine of less than 50 grams?
I plead guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
If I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. You understand that?
Yes, sir.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Silvertooth to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Silvertooth, other than as we've talked about it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Amadeo, do you wish to cover the factual basis?
I will, Your Honor. Thank you. Mark, I'm going to voir dire you, which means a few questions to establish the facts. We talked about this in jail the other day. Do you understand?
Yes, sir.
Okay, Mark. I'm going to bring you back to July 19th, 2023. On that day, were you in the city of Adrian?
Yes.
And is the city of Adrian in the county of Lenawee?
Yes.
And is the county of Lenawee in the state of Michigan?
Yes.
On that day, did you have a substance in your possession?
Yes,
What was the substance?
it was cocaine.
Okay. And while you had cocaine, was it less than 50 grams on your person?
Yes,
And was it your intent to deliver that cocaine to make a sale?
yes,
And did you know it was illegal to possess cocaine?
yes,
And is it true you did not have a medical card or anything that would allow you to have the cocaine in your possession?
no,
Okay. So on that day in question in the city of Adrian, it was your goal to sell less than 50 grams of cocaine. Is that accurate, Mr. Silvertooth?
yes, sir.
Your Honor, I think that covers the elements in venue.
Raises and stuff.
All right, I got something.
Mr. Hartung, are the people satisfied?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Hartung?
It has, Your Honor.
Mr. Amadeo?
It has, Judge. Thank you.
I will accept the plea that has been given understandably, voluntarily, and accurately. Mr. Silvertooth has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, except has been set forth on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for February 27th at 8:15 a.m. All right, and then with respect to the 21 file, the violation of probation, Mr. Silvertooth, do you understand that you have a right to contest that violation of probation charge and have a trial on that?
Yes,
Do you understand that throughout that trial, you would be presumed innocent until your guilt was proven by a preponderance of evidence?
yes,
You would again have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have the court order any witnesses you have for your defense to appear at that trial. Do you understand that?
yes, sir.
You again would not be required to testify at that trial, and no one could say anything about you not testifying or hold that against you in any way. But you would also have the right to testify at that trial if you wanted to testify. Do you understand that as well?
Yes, sir.
How do you want to plead to the charge that you violated your probation by being in possession of cocaine on July 19, 2023, and having police contact on July 20, 2023, but failing to notify your probation officer?
I plead guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Has anybody threatened you in any way in order to get you to plead guilty?
No, sir.
So you were placed on probation in that 21 case back in March of 2022, is that correct?
Yes, sir.
And one of the conditions of your probation was that you were not to use or possess any controlled substances, is that correct?
Yes, sir.
And another condition of your probation was that you were supposed to report any police contact to your probation officer, is that correct?
Yes, sir.
And on July 19, 2023, did you in fact possess some cocaine?
Yes, sir.
And did you have some contact with the police on July 20, 2023?
Yes, sir.
And did you fail to report that to your probation officer after you had that police contact?
Yes, sir.
All right, I will accept that plea. It has been given understandably, voluntarily, and accurately. Mr. Silvertooth has had full knowledge of his rights. He's had competent counsel. Refer that to the probation office for an update of the pre-sentence investigation report. And with respect to sentencing, I previously said the 27th. Can we move that to the 28th instead?
No problem, Your Honor. 8:15.
Correct. So 8:15 on February 28th.
We'll do it.
All right, Mr. Silvertooth, when you do your pre-sentence investigation interview, please be truthful about the offense and about your background. Is there
Yes,
anything
sir.
else we need to address today?
No, Your Honor.
No, Judge, the only thing, could I just say, Mark, I'm going in the trial, but I am working on your property issue to try to help you. But I will come to see you after my trial, okay?
Okay, thank you.
Hang in there, Mark. Thank you, Judge.
Judge, can I have a breakout room with him just for a few minutes?
Yes, Mr. Amadeo, do you want to be a part of that?
Do you need me, Miss Walsh, or are you good to go?
I'm okay if you're okay.
I'm okay. Thank you, Judge.
All right, Mr. Silvertooth, if you wait there just 1 minute, I'm going to put you in a breakout room with Ms. Walsh.
All right.
Have a good day, Your Honor. See you, Doug.
Thank you. Okay, Mr. Silvertooth, you should have something on your screen asking you to accept or join the breakout session.
Okay.
Mr. Glazier, are you ready to proceed with Ms. Howell? You were muted, Mr. Glazier.
Yes, we're ready to proceed, Your Honor.
Okay. This is file 24-22073-FH People versus Amberlynn Louise Howell. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. I'm sorry, there's a second file, so it's 22-22072. I'm sorry, 24-22072 and 24-22073. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
E.B. McClure, on behalf of the people.
John Glazier on behalf of the defendant, Your Honor.
And where do we stand with Ms. Howell's cases today, Mr. Glazier?
Your Honor, she's going to plead guilty to count 2 of both files, with the understandings count 1 and 3, and any habitual. I don't know if there is habitual, but there would be no habitual offender aspect to these pleas.
Okay, Ms. McClure, is that a complete and accurate statement of the plea agreement?
Let's see. So she should be pleading to 1 count of uttering and publishing in file 2422072, I believe. Or I'm sorry, 73. And then in the other file would be count 1 forgery. So there's 1 forgery count and 1 uttering and publishing count in each file. So count 1 in one and count 2 in the other.
That would be different than what Mr. Glazier said. So Mr. Glazier, he's saying count 1 forgery in the 7-2 case and count 2 uttering and publishing in the 7-3 case.
Let me see. Yeah, that's correct, Your Honor.
Okay. Okay, and I apologize. So that would, it somehow slipped my mind and while we were talking about it. So the 7-2 case is the forgery or the uttering and publishing.
7-2 is, I gotta look at the sheet. Let's see, 7-2 is, or 7-3 and 7-4 is what I've got.
Yeah, that's what I had written down too, so I mislabeled them.
Yeah. So I've got a 7-2 ending in 7-2 and ending in 7-3.
So the 7-2 is the uttering and publishing, and the 7-3 should be the forgery.
Okay.
And the reason being is that in the one, there was I believe, there was a successful uttering and publishing, and in the other it was she uttered and published, but the bank had stopped the check.
Okay. All right, Ms. Howell, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Amber Lynn Louise Howell?
Yes.
Ms. Howell, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 24-22072-FH to count 2, uttering and publishing?
Yes.
Is it also your intention to plead guilty in file 24-22073-FH to count 1, forgery?
Yes.
Are you satisfied with Mr. Glazier and the advice that he's given you?
Yes, I am.
You understand that the maximum possible penalty for the uttering and publishing charge is up to 14 years in prison?
Yes, I do.
Do you understand that the maximum possible penalty for the forgery charge is also up to 14 years in prison?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court. Is that correct, Ms. McClure?
That's correct.
That's correct, Your Honor.
Is that also your understanding, Ms. Howell?
Yes, it is.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Ms. Howell, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, I don't.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about September 27, 2023, in the city of Tecumseh, County of Lenawee, that you did commit the offense of uttering and publishing?
Guilty.
And how do you wish to plead in file 24-22073-FH that on or about September 26, 2023, in the city of Tecumseh, County of Lenawee, that you did commit the offense of forgery?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges? I'm sorry, I wasn't able to hear you.
No.
If I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Howell to plead guilty?
None, Your Honor.
Ms. Howell, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
Mr. Glazer, would you want to cover the factual basis?
Yeah, Ms. Howell, on September 26th of 2023, were you here in Lenawee County in the state of Michigan?
Yes.
And on that date, did you have a forged check in your possession that you tried to cash?
Yes, I did.
And that was for $3,000?
It was.
The payee was Kristen Mogul. Do you know her?
No, I do not.
And the drawer was a Virginia Ward. Do you know her?
No, I don't know her.
How'd you come into possession of that check?
It was a group of people and someone told us to cash these checks and then took the money.
All right. So you knew that check was forged
Yeah,
when you took it in and tried to check it as cash. Is that correct?
that's correct.
Did you help do the forgery? You just knew that it was forged.
I just knew it was forged.
All right. And on February 27th of 2023, did you again have a forged check?
Yes, I did.
And you also presented that to be cashed as well. Is that correct?
That's correct.
And on that one's the same amount, $3,000. And it was, the payee was a Kristen Mogul and the maker was a Virginia Ward. Is that correct?
That's correct.
You didn't know either of those people, is that right?
That's correct.
And you knew that the check was forged, is that correct?
That's correct.
Of the two that were presented, did one of them actually get cashed and you got the money for it, you know?
Yeah.
And the other one you
Yeah.
didn't?
Mm-mm.
The other one you didn't, is that correct?
No, I didn't get it cash. That's correct.
Okay. I don't have any other questions.
Ms. McClure, people satisfied?
Yes, people are satisfied.
Has the court complied with MCR 6.302 B, C, and D? Ms. McClure?
It has.
Mr. Glazer?
Yes, Your Honor.
All right, I will accept the plea then. Please, they've been given understandably, voluntarily, and accurately. Ms. Howell has had full knowledge of her rights and she has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for pre-sentence investigation and set sentencing for February 28th at 8:15 a.m.
I have a quick question.
Okay, so one second, Ms. Howell, someone from the probation department is going to be in touch with you to do a pre-sentence investigation. When you do that interview, please be truthful about these offenses and about your background.
All right.
What was your question?
John, could you please review my prior history and then send me a copy of my guidelines, what I could be looking at?
Those will get sent to you.
All right, and then
in the PSI, we'll get the PSI and we'll send it to you. And then we have a right to either object or disagree with how the sentence guidelines are calculated. if I think they're wrong or if you think they're wrong.
All right, that's good. Thank you.
Hey,
Do we want
Okay,
to,
I'm sorry, we also need fingerprints in both of these files, so we're gonna need an in-person writ for the sentencing hearing so that we can get fingerprints done.
I've done fingerprints for the other counties here. Usually I've done it twice already.
Yeah, you have to have a set of fingerprints taken for each file, so the ones done in the other counties don't help us.
No, I understand that. They always pull me up to receiving to re-fingerprint. So I don't know
Okay,
about it.
if they can get that done, then we can modify the writ if you don't want to have to come in person, but for the time being, I'm gonna order the fingerprints and request an in-person writ. If we get the fingerprint information back in time, we will change the writ to a Zoom writ if that's what you want.
Yes, please.
Okay. All right, so I think you're all set then, Ms. Holly, you're free to go.
All right, you guys have a good day.
Thank you. Okay, and then Mr. Glazer, I have Mr. Clark here in the courtroom in person. Do you need to speak to him?
no, I don't believe so.
Okay. Mr. Clark, do you want to come forward and stand at the podium? Okay, I apologize. I need to take a brief recess. I'm going to step out. Ms. Clark, you can just take a seat back there. We can resume once you are, or once I'm back. All rise. All rise. Okay, Mr. Clark, you can come back forward to the podium. This is file 24-22077-FH People versus Larry Dean Clark. We are here today for a pretrial conference in this case. And also for a arraignment on an order to show cause relative to an alleged violation of bond conditions. We are proceeding today partially in person and partially by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, at the people?
And Mr. Glazer, step away. Mr. Glazer, are you there? Oh.
Yeah, sorry, I forgot.
Oh.
Yeah, John Glazier on behalf of Mr. Clark.
All right, let me address the show cause order first, and then we'll continue with the pretrial. So, sir, you're Larry Dean Clark?
Yes, sir.
Mr. Clark, have you received a copy of the motion affidavit in order to show cause?
No.
Your Honor, I didn't receive anything either. I was unaware there was a motion or any type of hearing set on a bond violation.
Also, I have no idea what that before. Your Honor, I'm sorry.
Just please don't say anything. I've got to do a couple things first, and then I have to advise you of your rights before you speak.
Yes, sir.
All right, I have just emailed that to both Mr. Glazier and Ms. McClure, and Mr. Clark, I believe the bailiff handed you a copy of the motion affidavit in order to show cause. Is that
Yes,
right?
sir.
All right. So that document alleges that you have violated your bond conditions by failing to set up 2 times weekly testing with Mr. Coast after you were released from jail on December 9th. The maximum possible penalty for a contempt of court, which is what a violation of bond conditions is up to 93 days in jail or $7,500 in fines. You do have the right to be represented by an attorney with respect to that issue. You're obviously already represented by Mr. Glazier on the underlying charges. Do you want him to handle that for you as well?
Yes, sir.
All right, Mr. Glazier, do you want to speak to him about this?
I would, Your Honor. Mr. Coast is in the waiting. Yeah, I should, Your Honor, but I can talk to, I'd like to put this out a week if I can and have him get a hold of Mr. Coast and set that up. I'm not sure of why it was.
I'm already doing through this, right? I've been doing my drops.
Through who?
Through my probation officer downstairs. Because it hadn't been found over, so I had set it up downstairs. I had no idea I was supposed to get hold of Mr. Cost, but I've been doing my.
Your Honor, this sounds like something, if we adjourn it out a week or two, we'll get it taken care of. I need to adjourn it anyway because Mr. Clark is supposed to come in and see me, and there's a witness that I need to talk to. Do you know when we're gonna be able to do that, Mr. Clark?
Hopefully the beginning of next week.
If we could adjourn this out 2 or 3 weeks, And I'll clear up the thing. Evidently, he's testing downstairs and not upstairs.
Well, I'm on probation upstairs also, so they're supposed to be sending, Mr. Stevenson, like, results too. So,
All right, well, we'll clear that up. You come in and see me, okay?
yes, sir.
Judge, I can clarify that he did drug test on the 14th in district court, and we did get verification that that was negative. I don't know anything else about the bond conditions, though.
So I'll adjourn this to February 5th at 8:15 a.m. Mr. Clark, I need you to get in touch with Darren Coast in Circuit Court Pretrial Services on January 28th at 8 a.m.
Yes, sir.
Okay, he's out until then, but that's the first day he's back, so you need to get in touch with him on that day.
I'm still doing my drops regardless. Yeah.
Yeah, you still need to do all that other
Yes, sir.
stuff, but you gotta contact Mr. Coast on the 28th at 8 a.m.
Yes, sir.
Mr. Coast also included in his note that he sent mail to your address on Ruby Street, and
I've been having issues with my mail. I actually just.
are
put
you
a
still
stop
at
hold on-
that address?
Yeah, I just put a stop hold on my mail that's going there because I didn't get my driver's license sit there either, so. I actually get.
All right, so,
reordered.
so get in touch with him on the 28th at 8 a.m.
28th.
All right, and you need to be back here on February 5th at 8:15.
All right, do I get paperwork for that or?
That will go through your attorney's office, so if there's any paperwork on that, he'll send it to you. Mr. Glazier, will you do that stipulation in order, please?
Yeah, was I supposed to send something to Mike? I wasn't listening.
He's asking if he's gonna get a written notice in the mail about his next court date.
Yeah, hold on. We don't usually send them out. 2337 Ruby Street.
Yeah, I can just stop over and get it if you guys got a copy, if you can give me a copy of it.
Yeah, or you can just write it down now.
Right, yeah.
You
I
know?
don't have no, I ain't got a pen or nothing on me.
I think it's easier if you write it down and we make sure you got it.
Yeah, for sure. All right, can you say that time again, January 28th for Mr. Cost?
Correct, at 8 a.m.
And February.
February 5th at 8:15.
Yes, sir.
Okay, so you are all set for today then, Mr. Clark.
Thank you.
All right, make sure you set up that appointment that we talked about.
Yes, sir, I'll get a hold of you.
All right, thank you, Your Honor. That's all I have on that one.
Okay, and Mr. Glazier, I have Mr. Flores logged in on Zoom. You need to speak to him.
Yes, I do, Your Honor.
All right, Mr. Flores, I'll need you to unmute your device, please. Okay, and if you give me 1 second, I'm going to put you in a breakout session so you can speak to Mr. Glazier. myself and one Simmons.
Probably get into the figures. Could we get Antoine Simmons in a room, please? Thank you. Bye.
All right, this is file 24-22069-FH, People versus Emiliano Julian Flores. We are here today for a pretrial conference case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
Steve B. McClure, map of the people.
John Glazier on behalf of the defendant, Your Honor, Mr. Flores.
All right, Mr. Glazier, where do we stand with Mr. Flores's case today?
Is this an arraignment or a pretrial, Your Honor?
This is a pretrial.
All right, Your Honor, we'd ask to adjourn this out for a second pretrial. There's a plea bargain about dismissing the habitual. My client doesn't think he has a habitual. He says that was supposed to have been dismissed, and we need to check on that. So he's going to come in to see me, and we'll go over it at that time.
Okay, Ms. McClure, is there anything we need to address from the people's side?
No, just any documentation as it relates to that habitual, just forward to us and we can reflect that change.
Okay, how about February 19th at 8:15 a.m.? Yeah, and Mr. Glazier, would you prepare that stipulation in order, please?
Yes.
Okay, Mr. Flores, your next date is February 19th at 8:15 a.m. You'll log back in using all the same Zoom information that you used today.
All right, thank you so much.
Okay, thank you.
All right, thank you, Your Honor.
Bye.
Okay, and Ms. Kately, Mr. Murphy just got logged in here. Let's see, Mr. Murphy, do you need to speak to Ms. Kately?
If I could, please, Your Honor.
Okay, so Ms. Kately, there's an iPad just outside the door. If you step outside, you should be able to log in on that. I think it's the only option it gives you. Mr. Goldstein, I have Mr. Simmons here. Will you need a breakout session with him before you proceed?
No, Your Honor.
Okay, give me
No.
1 sec.
Well, no, I didn't even know I had court today. Hello?
Could you step outside?
A second.
Log in the iPad. Thank you. Okay, so let me see. We are on the record in file 25-22105-FH People versus Antoine Lamar Simmons. We are here today for an arraignment in this file, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung.
Good morning, Your Honor. Doug Hartung appearing for the people today.
David I. Goldstein appearing on behalf of the defendant.
And Mr. Goldstein, does Mr. Simmons wish to have the information read?
No, Your Honor, we're familiar with its contents. We waive reading and ask that a not guilty plea be entered.
All right, I'll enter a not guilty plea for Mr. Simmons. We can set this for a pretrial.
Your Honor, I'm going to be unavailable from the 15th of February till the 20th of March. We'd like to do this before, if we can have either the 5th or the 12th of February.
Yeah, we can do February 5th.
Okay. And then Mr. Hartung and I are going to be scheduling. We need to speak to you about, we've discussed possible resolution, but it's going to take some input from the court. So we're going to schedule a conference with you between now and that date.
Okay, so February 5th at 8:15 a.m. And yeah, then just contact Francis and she'll get you on the schedule for a bench conference.
All right, we'll do that. Thank you, Your Honor.
All right, anything else we need to address today, Mr. Goldstein or Mr. Hartung?
No, Your Honor.
No, Your Honor. Thank you.
All right, Mr. Simmons, you can let the officer with you know that you're done with court for today. Okay, Ms. Bokor, are you able to hear me?
Yes, can you hear me?
Yes, okay. I just wanted to let you know that we're waiting on Mr. Malero to get logged in here. He is over in Judge Angelone's court handling cases over there. So just going to put you back in the waiting room. As soon as he gets logged in here, I'll bring you back in and we'll get to your case.
Okay, sounds good.
One second, guys. Oh, okay, hold on.
Okay, Mr. Stevens, are you able to hear me?
I hear you. Can you hear me?
Yes, I just wanted to let you know that Mr. Malero is handling cases in Judge Angelone's court right now. So he's he's tied up, not able to be here right now. I'm just going to put you back in the waiting room. As soon as he gets logged in here, I'll bring you back in and we'll get to your case.
All right, thank you.
Ms. Woolley, are you able to hear me? Can you hear me, Ms. Woolley?
Can you hear me now?
Okay, yes, we can hear you now.
Okay, sorry.
No problem. Mr. Malero, your attorney is in another courtroom right now. I just wanted to let you know it's going to be a few minutes until we're able to get to your case. As soon as he gets logged in here, I'll start working on his cases and we'll bring you back in at that time.
Okay, thank you so much.
Okay, Ms. Kaylee, you can come forward to the podium. This is file 24-21883-FH and 24-21, sorry, both 24-22053-FH, People versus Taylor Lee Cately. We are here today for pretrial conferences in both of those cases. Appears there are also some alleged bond violations that need to be addressed as well. So first, let me ask the attorneys to place their appearance on the record, beginning with Mr. Hartung for the people.
Your Honor, Doug Hartung appearing for the people on the file that ends in 83FH.
And Phoebe McClure appearing for the people on the file ending in 53.
Okay.
Matthew Murphy appearing on behalf of Ms. Cately.
All right, and Mr. Murphy, where do we stand with Ms. Cately's cases today?
Your Honor, the plea offer from Mr. Hartung in file 2421883FH, I believe, is for Ms. Cately to plead to one count of possession of methamphetamine and an added count of aggravated domestic violence, which I believe will be count 5. And I was trying to find any further agreement about Ms. Cately's Ms. Cately is currently in mental health treatment court. I believe that there was a requirement for her to complete mental health treatment court under that. I wasn't sure if there was a mention about suspension of jail sentence, though. I thought there was going to be, but I can't find a plea agreement, so I honestly don't know if Mr. Hartung was offering that or not. And in file 2422053FH, Ms. McClure relayed that there would be a plea offer for Ms. Cately to plead as charged to possession of methamphetamine, I believe, with no habituals on the matter. Ms. Cately does wish to plead to possession of methamphetamine in both files and the aggravated domestic violence. Again, I just want clarification from Mr. Hartung in regards to anything further from his plea offer.
I guess I'll ask Ms. McClure. My case, I believe, came first, and I think the jail probably would be more properly sentenced on the second file, but I don't have an objection to doing that. I know she's done some jail time and some rehab time already, but I'm not opposed to that as it relates to my file.
I guess my preference is we wait till sentencing and make that determination. So I would prefer not to make a sentence agreement just to see how she does continuing on bond, because obviously her history suggests she does not have a good track record of that. So I guess I would prefer not to make a sentence agreement and see what Your Honor wants to do at sentencing.
All right, Mr. Murphy, does she still want to proceed, or do you want to speak to her again?
Could I just speak to her briefly in the hallway to confirm, and then we'll proceed on the record?
Yeah. Okay, so Ms. Kaylee, you want to step back outside the hallway? Okay, Mr. Murphy, do you know how Ms. Kaylee wishes to proceed today?
She wishes to proceed with the plea today, again, Your Honor, in file 2421883FH. She will be pleading, let me just pull that up right now, to the amended information that we received this morning. So she will be pleading to count 4, possession of methamphetamine, and then an added count 5 of domestic violence aggravated in that file. And then in file 2422053FH, she will be pleading to count 1, possession of methamphetamine. I don't believe there's a habitual offender status or any supplements on that, but they will be dismissed if there was.
Okay, Ms. Kaylee, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And you are Taylor Lee Kaylee.
Yes.
Ms. Kaylee, you've heard the statement of your attorney and the prosecuting attorneys. Is it your intention to plead guilty today in file 24-21883-FH to count 4, possession of methamphetamine?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes.
Is it also your intention to plead guilty in that file to aggravated domestic violence?
Yes.
You understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $1,000 fine?
Yes.
In file 24-22053-FH, is it your intention to plead guilty to count 1, possession of methamphetamine?
Yes.
And you understand the maximum possible penalty for that offense up to 10 years in prison and or a $15,000 fine?
Yes.
Are you satisfied with Mr. Murphy and the advice that he's given?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That is correct.
Mr. Hartung?
Other than what's placed on the record, that is absolutely correct, Your Honor.
And Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Ms. Kate?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty. You do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Catley, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Right.
If you are not a citizen of the United States of America, conviction of a crime could result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about July 6, 2024, in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of possession of methamphetamine?
Guilty.
And how do you wish to plead in that same file, again, in the city of Adrian, County of Lenawee, State of Michigan, on July 6, 2024, that you did commit the offense of aggravated domestic violence?
Guilty.
And how do you wish to plead to the charge in file 24-22053-FH that on or about August 23rd, 2024, in the city of Adrian, County of Lenawee, that you did commit the offense of possession of methamphetamine?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept the pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Catley to plead guilty?
No, Your Honor.
No, Your Honor.
Ms. Catley, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty?
Yes.
Mr. Murphy, do you want to cover the factual basis?
Yes, Your Honor. Thank you. So first in file 2421883FH, Ms. Catley, were you indeed in the city of Adrian, County of Lenawee, State of Michigan on July 6 of 2024?
Yes.
And on that date and time, did you have in your possession some substance known as methamphetamine?
Yes.
And were you aware that that was methamphetamine when you had it in your possession?
Yes.
Okay. And on that date and time, did you also commit an assault upon Mr. Olmsted?
Yes.
And is Mr. Olmsted a person in which you had a dating relationship?
Yes.
Okay. And by virtue of that assault, you would agree that there was a serious injury to Mr. Olmsted's as a result of that?
Yes.
What did you do to Mr. Olmsted during that assault?
Threw a bat.
Okay. I believe we satisfied the factual basis for that file, Your Honor. I'll move on to the next file.
Are the people satisfied, Mr. Hartung?
Yes, Your Honor.
Okay.
Okay, now moving on to file 2422053FH. Ms. Catley, were you indeed, again, in the city of Adrian, County of Lenawee, State of Michigan on August 23rd of 2024?
Yes.
And on that day and time, did you have some methamphetamine in your possession?
Yes.
And did you know that it was methamphetamine while you had it in your possession?
Yes.
Your Honor, I believe you satisfied the factual basis for that file as well.
Ms. McClure?
Yes, sorry, I couldn't get my computer unmuted.
Okay. Has the court complied with MCR 6.302 B, C, and D, Mr. Hartung?
Yes, Your Honor.
Ms. McClure?
It has.
Mr. Murphy?
Yes, Your Honor. Thank you.
All right, I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Ms. Kately has had full knowledge of her rights and she has had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for February 28th at 8:15 a.m. Ms. Kately, someone from the probation office is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Okay.
And Ms. Walsh, should she just step across the hall to the probation office and leave her information there?
Yes, please.
Okay, so they'll have a packet of stuff for you to pick up and leave your address, telephone number with them across the hall. With respect to the pending bond violations, I do have a note in the file from Mr. Coast recommending that we set those out because Ms. Kately has been tested negative, so we'll set those out and determine what to do with those later.
Thank you, Your Honor.
So Ms. Kately, you are all set for today. You just need to step across the hall to probation.
Thank you, Ms. Kately. You have a good day.
Thank you.
Your Honor, I believe that that's all that I had until 10:30 with Mr. Vargas, so I was going to log back into Judge Anselm's court now.
Okay, thank you.
Thank you.